Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Hello, everyone. Welcome to today's Savant Live webinar. Thank you so much for joining us. We'll be discussing how to settle your parents' estate. My name is Alaina Davalos, and I am a wealth transfer advisor here at Savant Wealth Management. And joining me today is Mike Cyrs, our Senior Director of Wealth Transfer. Welcome, Mike.
It's great to be here. Thank you, Alaina.
So I know this is a hard topic for a lot of people to discuss. So the agenda today will be pretty broad, focusing first on those immediate steps to take after a loss. We'll then be discussing understanding the will and other legal documents, as well as financial and property management during the probate process. And lastly, we'll conclude with some long-term planning advice and how to move forward. Mike, can you get us started from here?
Sure. Thanks, everybody, again for joining us today. This is a topic I think that affects all of us. We want to know what to do and the steps that need to be taken if something happens to a loved one. So it's a very practical topic. I will say this at the outset. It's one of those things where, depending on the assets and the makeup of the estate and the family, there's a lot of information that we have for you. And it's literally impossible for us to cover all of the different things that would need to be done at that time. But we're going to try to cover as many as we can, and we're going to save time at the end, of course, for Q&A. But hopefully this will be a very practical and an informative program for you today. So let's jump right in then, and let's start with the immediate steps after loss. And I think there's a big misconception with respect to this, and I want to clear this up at the outset. Many people think, boy, what I need to jump in. I need to contact a lawyer or the accountant and notify them. There's something that must be done from a tax perspective or from a legal perspective. And that's really not the case. At this point in time, everything legally and from a tax perspective, that can take place over time. So, for example, estate tax returns aren't due until 9 months after the date of death, and income tax returns aren't due until April 15th following the year of death. And there are other tax elections that might be applicable from a strategic perspective, valuing assets. There's an alternate valuation date, 6 months from the date of death, et cetera, et cetera. But there's literally nothing that needs to be done right away. So, the important thing I think to know is take your time and go through the process. Take time to go through this grieving process, and knowing and having the assurance that there's going to be time to address legal and tax matters, and there's almost nothing that can be done by you that's going to mess up that process. Okay, so if you want to jump in and somebody wants to pay, for example, some bills or some expenses, the Trust and Trustees Act is going to allow these to be reimbursed from a trust, or the Probate Act is going to allow them to be reimbursed by an executor. So if you front some of those expenses, you're not going to make a mistake. There's plenty of time to clear up all the legal and tax matters. Just relax, take care of the grieving process, the funeral, the burial, the arrangements in that regard with a family. And it's super important to do that because that time that's spent there, I think this is a time for family to get together, to reconnect, to celebrate that life and to go through that process. And I think it will be beneficial later on, to the extent, and this is what the studies say, that you spend some time, not jumping into the legal and tax matters, but taking time for grieving. They say there are 3 C's with respect to this process. A successful sort of the ABCs of the 3 C's, choosing people to connect with, connecting with them, and then communicating with them over a fairly long period of time, because there are these stages from shock to denial, to anger and bargaining, and that leads to, of course, to the acceptance and the hope, et cetera. So,
Mike, can I ask you a question?
Sure.
So, in that scenario, how would you handle a family member who's sort of pushing for a quick estate? Someone that's saying, where's my inheritance? When am I going to get things? Why isn't this moving forward? Do you have any advice for that scenario?
Yeah, I think what my advice would be was it'd be just to take some time and say, we're getting to those matters where we have to uncover the assets, the beneficiary designations, we have to review the documents. We weren't intimately, nobody's really intimately familiar, I think, with mom or dad's affairs or grandma and grandpa's, and it takes time. The steps that need to be done are going to be based upon the makeup of the assets and the profile of the estate plan, whether it's a trust or a will plan. So it's best just to take some time, and that's kind of the message that I would confer, to sort of slow that down a little bit if possible. And sometimes I think, Alaina, in a way, you want to just, if you can focus on the grieving and sort of those initial matters, it allows for a better outcome later on, because you don't rush to anything that needs to be done from a legal or tax perspective. So
Yeah, or have anybody make some foolhardy mistake that's going to damage those family relationships.
it,
'Cause I
it
think in those initial months, that's what it's really about, is making sure that your family is still going to be connected moving forward.
yeah. Now, a couple of tips. One of the things, in this area of immediate steps after a loss, that one of the areas that can be a point of contention is disposition of remains. And there can be a lot of disagreement here. So statistics tell us now that about 2/3 of disposition of remains is cremation, about a third is burial. People are moving from state to state and relocating in their retirement years, often in the South, et cetera. And so they don't, there can be a disagreement that can arise among the family as to the location of the disposition of remains, and even amongst family members, children, as to a cremation or not, given the fact that it is pretty common. And so what I can consider to be, important to know here is that there is a hierarchy for disposition of remains. If nothing has been done, there is a statutory hierarchy of who has authority. And the first in most state statutes is the executor. But as we're going to find out, an executor doesn't get appointed until a will is filed and the probate process is commenced. So that can take quite a bit of time. And the next person in line is the spouse, and then it's children. And if there's more than one child, it's a majority of the children, a majority vote of the children. So you're kind of left with this hierarchy as to disposition of remains, which, again, it can be a little bit contentious among family. Depending on your state of domicile, you may have a disposition of remains act. It's like a mini power of attorney that you can sign, usually in the presence of a witness and a notary, et cetera, where you say, this is the person who has responsibility for that decision, my spouse, my children, in such an order. So you might look to see if you can settle it with that sort of mini power of attorney. Some states also, in their statutory form power of attorney for healthcare, will have a special paragraph or provision where you can cover this. And it's the one piece of authority. So if you think of a power of attorney for healthcare, where the agent can make decisions regarding medical treatment, hospitalization, healthcare, and even end-of-life decisions, there may be a section that they can cover where they can extend that authority post-mortem into disposition of remains, and you might take advantage of that. So rather than relying on that hierarchy, perhaps, second level is the disposition of remains, and then the third tier would be the power of attorney for healthcare. So a good way to alleviate conflict here as well. Now, big topic is pre-arranging and prepaying funeral services. I've always been a strong proponent, and having been in private practice and now a decade here with Savant, the more you can do ahead of time, that's what planning is about, estate planning, whether it's, your trust or your will, or whether it's the pre-arrangements for funeral, burial, cremation, et cetera. The more planning you do ahead, the more certainty and specificity you provide for family, the clearer the objectives are, the less opportunity there is for conflict, and the smoother the bridge is going to be, through that troubled time period. So you can pre-arrange by contacting a funeral home. You don't have to prepay. Prepaying is another opportunity. But pre-arranging is just fine. The funeral homes are happy to go through that process with you. You don't have to pay. You can check the boxes, pick everything out, go through the checklist, put that record then in a safe place, and let your family know where it's at. And a lot of that is done ahead of time. If you do want to prepay, there are different ways to do that with contracts that are either guaranteed or not guaranteed. And for those that are guaranteed, what that means is it will cover the costs no matter what they are. And so if there's inflation, and there's an escalation in costs, you'll be covered under a guaranteed arrangement. It often brings in play a third party insurance element as well. Or you can have a non-guaranteed, which is more like a premium, a fixed dollar amount that you set for those pre-arrangements. I think that can work, but I would suggest at least going through into a pre-arrangement process, even if you do not prepay. So
say for example, though, my parent just passed away. How would I know if they've prepaid, if they've taken care of this at all? Where would I find that information?
Yeah, that's a great question, Alaina. And what I recommend here, we have on the next slide, we have a trust and estate administrator's guide. Well, we also have a checklist that we're going to send to you at the conclusion of our program, Navigating the Loss of a Parent, where you can go through and know exactly what to do. But we also have a checklist, a trust and estate administrator's guide. It's about a 14-page dump of information. And what I suggest is everything be pulled together on that checklist and put in a file that is in a safe place, and let your family know where it's at. So if you've put together a record at a funeral home that's going to make notation of these different decisions and items, and then you complete the trust and estate administrator's guide, keep this at home, keep it in a safe place, let family members know where it's at. They don't need copies of everything that's in there. They don't need to necessarily have a review of that information during lifetime. They just need to know where it's at and how I get to it. Okay. As people get older, they might share that information with them, but having the repository, knowing where it's at in a particular location, and then putting in there, sometimes people will, in addition to the arrangements that are pre-made with the funeral home, and the identification of assets and usernames and passwords and families and alumni to be contacted. And if you're a veteran, you might even have a VA Form 27, 2008 filled out for the flag that is going to be made available to honor that service member's contribution. All of that can be put in that place, and then there'll be an identification as well of that funeral home, and then there will be also more information. Now, the benefit of engaging the funeral home, a couple of things I'd say here. Most recent statistics I have are that 87% of funeral homes in the United States are family owned. So you tend to get people that are they're available. There's kind of a continuing thread to help the family. They're going to also help with notifying Social Security, helping you with the veterans arrangements. They're gonna have a whole litany of things that they're gonna assist with as well. So I'm a big fan, again, pre-arranging, complete a trust and estate administrator's guide, have this Navigating a Lost Parent checklist available, and then identifying that place with your family to go get it when needed.
Oh.
All right, so let's talk about, Alaina, the house and the personal property items. This can be a place where, again, somebody passes away, the family members are coming in, all of a sudden they're saying, well, grandma wanted me to have this, or mom or dad, it's an item of, perhaps a item of jewelry or something like that. And then there's also the security for the home itself. And two super important and prominent areas I think we need to spend a little time. So let's transition from the immediate loss, which is wait on the estate trust and legal matters, plan ahead, consider pre-arrangements with the funeral home and that involvement, and organize your record book and your file. And let's get into now, some of the things that need to take place with respect to the home and the personal items.
So, Mike, I'm sure it was the same when you were in private practice, but when I was working as a probate attorney, I had so many clients come to me and say, what do we do about the house and my parents' personal effects? No one's living there. Is it safe? Who's going to pay the bills? Can I get reimbursed? Please tell me, how does this work? And these are very legitimate concerns, because there is that period of time between when someone passes away and while the estate is being settled. So who's going to be responsible for taking care of those sort of physical objects? And like you mentioned earlier, that's going to rely a lot on the executor of the estate or the successor trustee of a revocable trust that owned that real estate. Those are generally going to be the only people with the legal authority to access the home, to remove personal property from the home, and to authorize an appraisal if need be. Those people are also going to have the obligation to pay the bills and make sure that the property doesn't fall into disrepair before it's transferred to its eventual owners. Some things that we would recommend would be to make this as easy as possible, would be to change the locks as soon as you can if you're that executor or trustee, or to recode the security system. Make sure first you can get in there, make sure second no one else can. Also, because of modern technology, there's a lot of things that you can install, any sort of video camera, any sort of lockbox, whatever you need to make that property safe. The other thing too that is going to be very important is to make sure that the utilities continue to be paid. The executor or trustee or whoever else is responsible, they can get reimbursed from the estate for these expenses if they've been paid personally. And the last thing you would want would be for your home to be damaged because the AC was cut off in the middle of Atlanta in the middle of summer, or the gas bill went unpaid in the middle of winter in Rockford. Not paying the utilities can damage the property, so please keep that in mind. Another recommendation that we make is to have the mail forwarded to the executor or the trustee's primary residence. And that's going to be especially important if you live out of town. If you're not regularly driving by that real estate, make sure that mail is being sent to your home or you have someone collecting it for you. This can help not only to keep track of those utilities, but I can also give you more information about the decedent's estate. You could get a bank account statement for an account that no one knew about, or a tax bill for a piece of real estate that hadn't been accounted for previously. A lot of information can be gained in the mail.
I would just add as well, in that record book, Alaina, it was a good place, security system information, the codes, who to contact, the passwords. Digital assets have become a big issue with respect to advanced planning and making sure that people have access to accounts that need to get shut down. And that means in that record file, kind of where you have the arrangements ahead of time, is to make sure you record all that information and make it easier for family to administer those things ahead of time.
So one of the things that we've been talking about just around the office lately is something called the legacy contact that you can set up in an iPhone. There is an Android and a Google phone equivalent. I'm just an Apple user myself, so you might have to Google that. But setting up that legacy contact in your phone will actually be able to provide your executor or trustee, whoever you give that contact information to, a huge toolbook, a huge look into your life, including access to the security of your home with less hassle than, if they were having to wait for the probate court to issue the letters testamentary, or you're waiting for the legal aspect to occur. So I highly recommend looking up that legacy contact or something similar on your phone, because we all have so much information that we keep on our phones nowadays. But just generally, and that sort of goes into play with our next topic about open and honest communication. If you're doing your estate plan, you want to have open and honest communication with your beneficiaries, your family, anything to keep that process moving smoothly. But also, if you are the executor of your parents' estate or you are the trustee of their revocable trust, this open and honest communication is again just as important, so that you can let your siblings know, you can let other beneficiaries know what's going on, what the steps are if there's issues. So long as you feel comfortable, there's a lot of tension that can arise between family members about what should be done. Everybody has an opinion. Y'all will experience this, I'm sure, during life, and it is especially relevant at death that everybody thinks they know what mom and dad wanted. And I have seen more in family fighting, both in my own family and with clients, over stuff than I ever would have thought possible. Siblings, whether they are 1 and 3, like my children, or 61 and 63, like my aunts and uncle were, love to fight about things. And this fighting can ruin relationships. So long as you are having those open and honest communication, let your siblings know no one is getting this property right now. We're not making any distributions until the tax bill has been paid. If you are the executor or trustee, you have that legal authority and you can set those guidelines. So just try to have those conversations respectfully and with transparency. And this is going to be especially important if you know that you do not get along with one of your siblings, or if there's a high likelihood of fighting now that your parents are gone. If you know that's going to be the case, I would definitely encourage ahead of time you to encourage your parents to have those conversations with everyone so that everyone can get on the same page. And remember too that after a loss, this is a very emotionally driven time. And the last thing your parents would want would be for you guys to be fighting over their things. So encourage them to have those regular family meetings and explain why they made the decisions that they did. If you are the executor or trustee of your parents' estate, you do have a little bit more to worry about because you do take on that fiduciary duty status. And you could be sued by your siblings or other beneficiaries of the estate for a breach of fiduciary duty. To try to avoid that, make sure you keep records of everything you're doing, especially financially. If you know you have a tense relationship with someone, communicate via email, communicate via text. Make sure everything is written down, and that's to cover yourself. Try to avoid self-dealing, meaning try to avoid interactions between you personally and something you're interested in your parents' estate, for example. Don't sell or distribute assets to yourself before everyone else. That tends to create some problems. And that may be perceived as unfair to your siblings. And then just generally try to get the leader of your new family, try to be that leader. Realize that you've just lost your matriarch or your patriarch, and try to keep in mind that everyone is hurting. If your parents chose you to take on this role, they chose you for a reason, and feel free to embrace that when trying to move your family forward.
That's fantastic advice, Alaina. Thank you. The one thing I would add there, most modern estate planning documents, they allow, and most state statutes allow this as well. They allow the will or the trust to reference another ancillary document that can be utilized for the disposition of personal and household effects. So you can, through your will or through your trust, reference this other document that you're going to date and sign and update from time to time that's going to dispose of personal and household effects. It can't be used for accounts and real estate and other property. It has to be tangible personal property. So I think it's good to know that, because you might use that system to then specify personal items as to who they should go to, maybe even a child or a grandchild, again, jewelry, anything tangible personal property. And it can be, I think, very beneficial to resolve disputes, because it's specifically set forth personal property items in that disposition. And again, sometimes it's nice to do that ahead of time during lifetime, and then it's just outside the estate or the trust. It's not a part of, what's left for administration later on.
It's also something that, we're going to talk about the will and the trust in a second here, these legal documents, but that ancillary sheet that Mike's referencing, that is a lot easier and usually a lot cheaper to amend than your will or your trust. So let's flip the script a little bit here. Mike, do you want to take it away on the will?
Sure. And we put this in here because when we create our estate plans, we have all these legal documents. We have the powers of attorney for property and healthcare. We have the living will. We have the will and the trust. And when it comes time to administer the estate plan in a postmortem context, there's a lot of misunderstanding with respect to who has authority and what that authority is. Okay, so we wanted to capture this. We've got a couple of tips with respect to powers of attorney for property and healthcare. When made, use the statutory forms, make them effective immediately versus upon, physician certification. Have multiple agents named in succession if you can. So there's many people named. Big thing here is the authority under powers of attorney terminates at death. There's no ongoing authority, post-mortem. So if somebody was mom or dad or grandma and grandpa's or somebody else's agent under a power of attorney, that authority ends. The job is over, and it doesn't even matter that you had that job during lifetime. It's over at that point in time. There's no continuing authority. And this can be important to point out. I think that it's a good idea, it can be a good idea to have a small account that's differentiated, that's like a joint tenancy account. Maybe it has 20 or 30, there's a smaller amount in there, $1,000, and it's going to be used to pay bills and things like that. You might add a child as a joint tenant. Maybe it's the executor or the trustee. You note that in the account that this money is there for a quick, convenient, short-term access. You don't have to, in a joint tenancy account, you don't have to prove death to have that continued access. It just continues by what's called right of survivorship. And so there's an immediate access to that account. And that can be a really nice way to make sure that there's a mechanism in place to pay the bills and things like that. Many times accounts get set up during lifetime with a bank or with a custodian, and the child or somebody is named as an agent with a custodian. It's like a mini power of attorney over just that account. And so you might be going along thinking, boy, I can pay bills and I'm going to be able to do this post-mortem because I'm doing it now. And then all of a sudden, abruptly, you find that you don't have authority over that account, that it's not a joint tenancy account, that it's actually, a power, an agency account. And an agency account legally only exists while both agents are still alive. And as soon as the one, the agent that created the principal that created the account passes away, that agency terminates, and there's no ongoing authority. So it's important to remember that. Again, the only exception for continuing authority would be perhaps with respect to the power of attorney for healthcare and the disposition of remains, which I discussed a little bit earlier. Okay, now getting into the other two main documents, which is the will and the trust. So under a will, the terminology that's used for the person that's empowered to act is called an executor. And the executor gets their authority from the court through a very formal and public process called probate. And essentially, the probate process is, for anything that's in a decedent's individual name, the executor, it doesn't have a named beneficiary, so it's not a jointly owned account. It's in the decedent's individual name, and it doesn't have a named beneficiary. So life insurance, IRAs, annuities all have named beneficiaries. Those would not be probate type assets. But probate assets in a decedent's individual name get frozen, and the only way to unfreeze them is to go through this process where the court determines that the will is proper, it's been properly executed, it wasn't executed under undue influence or duress, and the executor is going to take over and accept the office and appointment, and then they're going to have authority to deal with those assets. A trust is it's very similar. It's also a legal document that names a person responsible for taking care of affairs. It also says how things should be distributed, like a will. So they're similar in those two regards, but they're entirely opposite and different in that in a trust context, the trustee has automatic authority upon death or disability to take over for the affairs of the grantor, the trust, the creator of the trust. So not public record, no need to go to court. And that authority extends only over assets titled to the trust. So this is where it's important to differentiate the different types of assets that exist at death, whether they're joint tenancy or in its decedent's individual name or whether they're in trust. You need to inventory all the assets, find out which court, which lane it's in, and then you'll know which type of authority is appropriate for administering those assets. So very different. Now, if you're named as an executor under a will, that authority is being named doesn't give you any authority whatsoever because the court hasn't appointed you. It's just a latent designation within a document. To get the authority as executor, you've got to go to court and go through this process where you're given these letters of office by the court. So if somebody walks around where somebody's named as an executor, it's kind of like a power of attorney for property that's no longer, relevant, doesn't have any authority. It's kind of the same type of thing. And that's why people will use a trust. And in the trust context, if you're just named as a successor trustee, you merely accept the office. You acknowledge the death of the grantor, you accept the office, and you're off and running administering the estates. I've had a trust estates administered within, literally 2 weeks of a funeral where everything is wrapped up. It's just that quick and efficient because there's no court involvement, no delay. So it's important to differentiate between these two arenas. We've got, a little piece of business. Next slide is even when you have a trust, okay, what you want to do is you're going to want to locate all of the documents, okay, identify the fiduciaries, and the last will and testament, the original, will always get filed with the court. So that needs to be located, and it needs to go to the court of the county of domicile, no matter what, whether you're using a trust form of administration or the will form. And that's there. There are state law requirements because the states want to flush out all of the last will and testaments. And so if they say, hey, if you're in possession of an original last will and testament, and you have to bring it to the courthouse within 60 days, now the court, within a short period of time, is going to have all of the wills, and it's going to be able to determine which is the official last will and testament, because it's requiring those wills to come to the court. Now, when they get filed, they're going to be filed non-probate. You're just simply filing it with the court, not necessarily probating it, which is a different process, as we've described, where the executor is appointed. Everybody needs to file it. You can get a certified copy of it when you file it and take that home with you, but the originals always reside with the court. Let's show this in a little bit of a diagram, and I think this will bring a little additional clarity, hopefully, to the different types of areas on this slide here. So here you can see all property in the United States, no matter how it's owned, no matter which state it is in, is going to fit into one of these 3 general primary categories or the trust category. You'll see on the left we have assets that are jointly owned. They have 2 names on the account. They're joint tenancy assets, okay? And when one joint tenant passes away, and it could be real estate, it could be a bank account, could be a stock certificate or investment account, and joint tenancy, when one joint tenant passes away by what's called right of survivorship, that asset automatically passes to the surviving joint tenant. Doesn't matter what the will says or the trust, it's its own transfer mechanism. It's complete. The court has no control over it. The executor has no control over it. It is its own independent structure for transfer. On the far right, you'll see in the diagram property that's in an individual name, but has a named beneficiary. So this would be IRAs, life insurance, annuities, and the like. Similar to joint tenancy property, doesn't matter what the will or trust says, unless the estate or the trust is beneficiary. In this case, the asset will pass. All you do is present a death certificate, and those assets pass to the named beneficiary, okay? Think of it as a contract, one-term contract. When I die, pay this asset to the named beneficiary if they survive, if not to the secondary beneficiary, okay? So those 2 categories are on the outside. We've got joint tenancy, multiple names on the far left. We've got individual property, but with a named beneficiary on the far right. In the middle is property that's in an individual name, no named beneficiary. And again, this could be real estate, this could be stock, this could be a car title, it could be any number of things. Those are the assets that get frozen or locked up. and the court then has to appoint an executor or administrator to unfreeze them and take possession of those assets, pay the bills, and make the distribution. And this is where you get that process where you've got to pay a fee, file a petition, an oath of office, a bond, an affidavit of heirship, demonstrate to the court that you're taking control of those assets and you're doing, what's required of you as an executor or an administrator under the last will and testament, and that you're getting those assets to the designated heirs. Now, why is it important to know these different categories? Well, the people who are named beneficiaries on the far right, they can be off filling claim forms out on life insurance. They don't need the executor's help. They're just off and running. And same thing on the joint tenancy side. Like, you have to identify, and one of the first things we do in a trust or estate settlement process is tell me about all the property and let's place it into one of these three categories so that we can start to unlock and unwind what needs to be done. Okay, so let's go to the next slide and we'll introduce really kind of the fourth way to own property, and that is a trust, okay? And here we have a diagram. It's for a joint trust, in this context, a husband and a wife, and the trust has the non-IRA assets and the home owned by it. The title to it has been deeded from an individual to the trust itself. And here you'll see, unlike the previous slide where you have to go to court to get the letters of office, here you'll see the little diploma looking icon. The authority is built into the trust. So think of it like, I trust my family. They don't need to go to court. They don't need to have the court overview the process, make sure the bills are paid, publish notice in newspaper to creditors, and all of the formalities of probate. I trust my family. They're gonna do what needs to be done, and that means that anything that's owned by this trust or payable to it at death by beneficiary designation, you're just off and running as a successor trustee. You'll fill out like I said, you might sign a document which says, I accept this appointment as successor trustee, and you'll get a new tax ID number from the IRS, and you are off and running, paying the bills and making distributions. So you can see why and how trusts can be such a clean and efficient way to administer one's affairs. But hopefully this diagram gives some clarity, because often it's not this clean. There are assets out there where the beneficiaries aren't aligned correctly, or maybe there's some loose assets that are in joint tenancy, et cetera, et cetera. So you really have to sort of work through these four categories on a case-by-case basis to know what needs to be done and on what type of time period. So probate as a whole, I just want to mention a couple of things. It's a great process. I mean, it works. It's been around forever. Some attorneys recommend it because it uses the court's oversight and overview to make sure everything was done correctly. It makes sure that the will is followed with court oversight, and the administrator or the executor is qualified and files that bond which I think could be appropriate. It makes sure that creditors are getting notified. So it is a clean process. It's just that most of the time it's going to be a year, sometimes longer, to get things done for assets that are in that probate process. I would note that if you have assets, depending on the state, that are in a decedent's individual name that would otherwise go through probate, that are of an insignificant amount, and that may be a $50,000 threshold or a $100,000 threshold, you can bypass probate if it's not real estate and it's of that insignificant value, by using what's called a small estate affidavit, which is like a 2-page affidavit that allows you to transfer title. So we often use that for cars, which often get left out of a trust, or some simple bank account, et cetera. So that's kind of the basics of how what the different roles are, how they work together, asset title, et cetera. So maybe do you have any comments, Alaina, and some other thoughts regarding trusts that you might like to share?
Yeah, for sure. And the one thing that I just want to reiterate to what you were saying, Mike, is that, these boxes make things look pretty easy. But if you are going through the probate process, if your parents have a will, you're going to have to probate that will based on how the assets were held. I do highly recommend working with a competent attorney. I'm a little bit biased. I'm sure Mike is too, but a good attorney will help to make this transition much easier and much smoother because anytime that the court is involved, there are deadlines, there are things you need to keep in control of and make sure things get filed on time. So having that attorney to help walk you through that process can be very helpful.
That's good advice.
Whereas on the other side, with a revocable living trust, because you don't necessarily have to go to court, you may not always need an attorney. They're there to help you if you have questions, again, if you're worried about your fiduciary duty. But, that revocable living trust is utilized to set aside assets for the lifetime use of, if you're married, that surviving spouse, and then to the beneficiaries after that, who are usually, your descendants, kids, things like that. Sometimes a revocable living trust can become irrevocable at the death of the grantor. That's most typically if you have one grantor, as opposed to if you have two grantors, let's say a married couple. A lot of times it's at the death of the second spouse that married couple's trust would become irrevocable. And that's important to understand, is when are the terms of this trust frozen in stone? So in our example here, we have a primary residence and a brokerage account that have both been titled in the name of the trust. And the terms of that trust allow the surviving spouse the lifetime use of the residence and all of the income from that brokerage account. The good thing about that sort of setup is that during the lifetime of the surviving spouse, assets that are in that trust may be protected. They may be protected from the remarriage of that spouse. They may be protected from creditors. And what this will do is that it will guarantee, to the most part, that some of the assets will go to the children at the death of the second spouse. So when we start talking about revocable living trusts that turn into irrevocable trusts, things can get very complicated there, knowing at what point that's going to happen and at what point those assets are, how much of those assets are available, income, principal, things like that. Those are called subtrusts. So if you ever hear that, that means it's a trust that's been created under another trust. Additionally, you can create these subtrusts for your descendants moving forward. These are called descendants trusts, dynasty trusts, cascading trusts. And what these trusts can do is they can take the kids' inheritance and they can protect them when it comes time to go to the grandkids and the great grandkids up for a certain period of years, depending on your state law. And while those assets stay in trust, they'll be protected from future divorce, from creditors, and if they're drafted correctly, from any future estate taxes. So sometimes, you may have inherited your assets from your parents, not outright, but you may have inherited them in trust. And, I think trusts sort of have a bad reputation. They're controlling from the grave. I try to talk to whoever I'm talking to about these subtrusts that, they're really more designed to provide protection as opposed to control. And so you may see this in the documents that your parents created. It's not necessarily a bad thing. It could have been done for protections outside of your control and to sort of create that generational wealth by making sure the gift that your parents left you will go to your grandkids one day and to your great grandkids and so on. They just cascade in future trusts. All of those provisions, those terms creating those subtrusts, they'll be found in the revocable living trust and sometimes in the will itself. So be aware if these subtrusts have been created, they're most likely designed for asset protection. They are also used for naughty beneficiaries. So, yeah, that may or may not be you. I think you'll know if your parents were trying to keep things out of your control, but so the other thing that we have to look at is, the distribution planning. You know, Deciding whether to have a will or a revocable trust is usually discussed during the estate planning process. Your parents would have talked with their estate planning attorney about what works best for their own plan. Some of those talking points are that a will has to go through probate, that Mike just explained, and that can add expense and delay. Some people, they would rather their children avoid that scenario completely. Wills, they also become public knowledge, and a lot of people are very cautious about what information they want their neighbors to know. With a revocable trust, on the other hand, property can be transferred immediately, as we've discussed, and without court involvement. However, those assets have to be moved into the trust during the grantor's lifetime, the person that creates the trust, and not everyone has the time or the mental capacity to take on that homework. So it may not always be an option for someone to create a revocable trust because they couldn't get it funded for one reason or another. Most likely your attorney would have discussed with their clients how to title different assets, including real estate. And this titling, Mike touched on this, how different assets are held, how they transfer. That plays into the overall picture of the estate plan because we want everything to be cohesive. Unfortunately, it doesn't always happen that way. Sometimes a beneficiary designation doesn't get updated the way that it need to be, or an asset didn't get moved into the trust and now it needs to go through a will. So there's a lot of minute details that go into estate planning, and sometimes they're not always effectuated the way that they need to be. So keep that in mind, and if you're struggling with your parents' estate plan, sometimes I would say, just try to give a little grace. It can be a very tedious process depending on the assets to do the estate planning. And not everything works as smoothly as it should. In an ideal world, it would. If you worked with Mike and I when we were in private practice, I'm sure those plans worked out great, but
Lots to think about. How about
the
estate
other,
taxes, Alaina? Let's cover just this a little bit and give some background here.
right, because this is the other, everyone's favorite thing to talk about is going to be estate taxes, which a lot of people are not familiar with because they don't come up that often. Um, so you may hear the executor or trustee of your parents' estate talking about estate taxes. Thankfully, these taxes impact very few families today. There's a current federal estate tax exemption amount of 13.99 million per person in 2025. So that means a married couple has to have about 27 to 28 million dollars of assets collectively before their joint estates would have to pay taxes. I wish every client and everyone I meet an estate tax problem. It's a good place to be at. There are also state estate taxes. So, for example, Illinois has a $4 million state estate tax exemption. So a married couple living in Illinois may have to pay Illinois state estate taxes if their collective estate exceeds that $4 million mark, but they wouldn't have to pay federal taxes. There can also be what's called inheritance taxes. And this is not very common. Pretty much it's just the state of Maryland, but check with your attorney always to make sure you're not going to have any inheritance taxes. Make sure you're familiar with your state's laws on the topic. But generally, most people do not pay inheritance taxes when they receive their inheritance tax. And the last thing to note too is that all of these tax rates vary. The federal estate tax rate, so once you've exceeded that $28 million, is 40%, whereas the state estate tax rates are usually much lower. Sometimes you'll see, and you'll see some of this planning, in estates that are a little bit bigger, especially with those wills and trusts that have created those sub-trusts. There's a lot of planning that can go into those documents that has to do with federal estate tax planning. So that comes up a lot in wills and trusts. Sometimes it's overkill, sometimes it's just a case, but that might lead to a bit more complexity in the estate planning documents that you're seeing. So the last thing that I want to talk about, when I mentioned before that there can be discrepancies between estate plans where you don't have everything lining up cohesively, is because of issues you run into with beneficiary designations. So some assets may pass under the estate or trust, like we discussed. Some assets pass automatically because of that joint ownership. And again, to reiterate, it is very important to understand those differences because misunderstandings can lead to conflict between the executor and other beneficiaries of the estate. So some of the things that we deal with every day are beneficiary designations because we're handling 401ks, IRAs, things like that. Those are assets that have those beneficiary designations, in addition to life insurance policies you'll see. So these assets will then transfer that account automatically to the named beneficiary once the death certificate has been provided to the account holder. It's really important, if you're looking at your own beneficiary designations, to consider who those beneficiaries are. The person that's named as the beneficiary or the entity, if you're choosing charity, they are free to use or transfer the assets as they desire. I run into a lot of problems with this when it comes to second marriages, for example. Someone will name their current spouse as the primary beneficiary and then their kids as the contingent beneficiary, not realizing that once the primary beneficiary, the new spouse, inherits that account, they can do whatever they want. They can completely get rid of the kids as the beneficiaries. And second marriage planning takes a lot of thinking and a lot of coordinating if you're ever in that situation, just because you have to make sure all of those pieces align if you want to make sure your kids are taken care of. To add more complexity to beneficiary designations, not only do you have to think about the people, but there are very specific rules when it comes to naming the beneficiaries of your qualified accounts. So your regular brokerage, no issue there, but your 401ks, your IRAs, you're on a 401k, the surviving spouse has a right by federal law to be the beneficiary of that qualified plan unless that right is waived in writing. They don't have the federal right. The federal law does not protect them to be the beneficiary of their spouse's IRA or Roth IRA. That's a slight distinction. But they can, once they've got access to that 401k, they can move it over to their own IRA. There's also different tax rules that are going to apply when you have a spouse as the beneficiary of a qualified account versus your children versus charity. There is a lot of tax planning that goes into who those beneficiaries are. So another thing to consider, you see your parents who've recently passed, you see that they have made these decisions on their beneficiaries. Maybe it was done on purpose. It could very easily have been some tax planning that went into that decision. Or it could be like my father, who still has my mother as the primary beneficiary of his 401k, which would be fine if they hadn't been divorced for 20 years. So those things also happen. We try to plan around those, don't we, Mike?
That's right.
Yep.
All the little permutations.
All the little, yep, there's a lot of things going on. So we're going to talk a little bit now just about financial and property management moving forward. So now that you've gotten a little bit more familiar with the legal jargon, let's talk about logistics, managing assets. So who is going to be responsible for managing the assets while an estate is open? And I hope you all know the answer to this question by now, that it's going to be the executor or the successor trustee. You know, they'll be the ones responsible for notifying the banks and the financial institutions of the decedent's death. They'll be responsible for accessing those bank accounts, paying the bills, or reimbursing someone who did pay the bills, as well as managing any real estate and taking care of and distributing personal belongings. They'll also be responsible for collecting any debts of the decedent, as well as paying the final bills, filing a final income tax return. So pretty much they'll be in charge of the money. They'll also be responsible, like I just said, for collecting any debts of the decedent and paying the final bills. This includes transferring or paying off any mortgages, any credit card bills, paying any outstanding promissory notes, pretty much taking care of any of the debt that the decedent had. There's usually something that goes into the local newspaper, a notice to debtors and creditors. Creditors don't really usually come forward, but debtors will, saying, hey, so-and-so owed me money for this. The credit card companies will usually file reports there. And so that's sort of going to be the big thing for the executor and trustee, is make sure all of those debts can be paid before the estate can officially close. And the biggest creditor that will sometimes arise is the IRS or your state tax assessor. Mike, do you want to tell us a little bit about that?
Sure. I think that, we're getting close to the end of our time together. And from an income tax perspective, I think maybe the way to simplify it is this, that think about, the time thread, and that, there's interest and dividends and tax consequences to the assets during lifetime. Those are picked up on a decedent's 1040 through the date of death. At the date of death, the Social Security number is no longer useful. We need a different tax ID number to pick up those attributes, because the U.S. Treasury is not going to allow us, the Department of Revenue, off the hook. So the Social Security number goes away. There's a simple process. You can do it online. You get a tax ID number called an EIN, and then you re-register the assets. They get a step up in tax basis. So if they've appreciated, the beneficiaries can receive that appreciation income tax free, and the asset income tax free, unless it's of course, has grown on a tax advantage basis, like an IRA or a 401k, a regular IRA, that is. Then the interest and dividends through that time period of administration picked up on a 1041, and then those assets are transferred to a beneficiary, and then the attributes are picked up on the beneficiary's 1040. So just remember that 1040, then 1041, then beneficiary 1040 again. And you've got to capture all of those tax attributes. You got plenty of time to do it. Accountants can even move the taxation around you if you don't get that EIN until a time period after the date of death. You kind of jockey the income where it's supposed to be. If the trust is handling everything, you don't need an estate EIN. The trust EIN can handle everything. And there's also an election you can make if you do have both an estate EIN, because you have estate assets and trust assets. You can merge those into the same EIN, and then notify the service that you're, again, ending those EINs, closing them out, and the assets are now with the beneficiary. Long-term planning in this regard. Important point here, I think, if you're acting as a fiduciary, people can argue about what you did as an executor, you're going to have the court to help you protect in that situation. But or as a trustee, did you collect all of the assets? Did you pay the bills correctly? If you took a fee for yourself, is that appropriate and reasonable? And so what you might consider doing is then having, putting together an accounting, and it may be required under state law, and there might be a format for that. So you want to check that, and then have the beneficiaries waive off and say, yep, you did everything you were supposed to, get that release. You could also keep a little bit of a reserve. For example, you might use a little reserve to pay, some of that income tax liability if it exists. But if you distribute all of the assets to the beneficiary, you're just going to have the bill for the 1041, because when a trust distributes or an estate out, to the beneficiaries end up owning that income tax liability that would otherwise belong to the trust or estate. So then you just need to sort of upfront pay for the 1041. So just a minute or two on reflecting and honoring, and then maybe we'll just take a few minutes for some questions.
So we've talked a lot today about the legal side of handling your parents' estate. And the way we sort of wanted to end this was to talk, about how much there's a lot of emotion. We realize that when a parent has passed away, it's not just the legal, it's not just the stuff, it's not just the taking care of business. And there's so much emotion to handle with the loss of a parent, especially now as we're heading into the holiday season. So, if you've received an inheritance, you can always consider using those funds to help create and honor your parents' legacy. Throw that big party for them or take your family on that trip to create new memories. A good friend of my mother-in-law's passed away a few years ago, and she left my mother-in-law a small inheritance. And my mother-in-law used that money to take us all on a trip to Italy. And while we were there, we said our toast to Teresa and we thanked her for the gift. It's the small things that can go a long way towards remembering your loved ones. And another really great way to help your parents' legacy live on is to give to charity. Make a charitable donation to your parents' church or an organization that was near and dear to them. Our Savant office here in Atlanta is sponsoring some local families for Christmas. We're buying toys and clothes and helping to make this a memorable time for them when maybe otherwise it wouldn't be. Doing something like that in honor of your parent could be a wonderful way to celebrate their memory and to have a real impact. So, as always, you know your parents best and you'll know how they would have wanted to have been honored. And so, one of the best ways, though, to conclude is the best way to honor your parents, especially if you've received an inheritance, is to make sure it's treated appropriately when it's passed to the next generation. And you can do that by updating your own estate plan. I've got this list here of things to think about: wills and executors, powers of attorney, coordinating beneficiaries. When I was in private practice, I had so many clients walk in the door saying their parents had just passed and they'd either had a horrible time and wanted to avoid that for their children, or the probate was super easy and they wanted to make sure that their children had that same experience. So, estate planning is not really for your benefit, it's really for those that you leave behind. So, I recommend not putting it off. Please go and get your documents done. And with those words of wisdom, we are done with our presentation for today. We won't have time to address everyone's questions live. So if you would like to discuss your unique situation, please schedule a complimentary 15-minute call by clicking the link in the chat to schedule a time that works for you. And then Mike and I are going to take a few questions.
Yeah, thanks. That's great. Thank you, Alaina. Wonderful job. And, This is as we said at the outset, there's just a lot of information we provide. We would need, probably a 3-hour program to cover everything, but hopefully we've given you a great, starting point, a framework to understand what needs to be done, sort of step by step, where to place your priorities. And you can review this and you'll get the link and kind of go through it again. But a couple of questions in the lightning round. Somebody asked a question regarding, can you use a beneficiary, to move the account at death rather than joint tenancy? You can. The downside to beneficiaries are that you have to prove death, and so that can be a required death certificate, and so sometimes that can slow things down. If there's an autopsy or depending on the cause of death, you don't get the death certificate and the documentation you need to prove death. Question came in regarding, automatic payment of utilities through accounts. Accounts don't get frozen at death. In the sense that if there's checks still going through or automatic withdrawals, they get frozen from outsiders taking money out, individuals, but not from the things that are going on. So you can kind of let that happen and let the automatic, start to shut off the automatic deductions later on. Don't worry that if there's a heating bill that's automatically paid, you want to take inventory of it, but it's unlikely the institution's going to get notice of a death and lock it down. I even used accounts. You can actually deposit to an account if a check comes in the name of a decedent post-mortem. You can, the bank will still take that as a deposit. It's just that you can't, nobody can take it out if that's an urgency until you get the letters of office put together. So a couple of questions there. Somebody had a question, I thought this was interesting, regarding co-executor or co-trustee with perhaps a family member that maybe there's some disagreements that are likely to happen. There are fiduciary duties that exist. So being a co-executor or co-trustee, if there's going to be problems, you might just step back and say, I'm going to let the other person do this, knowing that in the context of a court, the other person's going to be responsible to the court. And I'm going to be able to sit back and just wait for the inventory and the accounting, et cetera, and always be able to question things. Same thing with the trust. Nothing's worse than having, two fiduciaries who are kind of struggling with one another. One person might just want to just let the other person take care of things and handle things. Any favorite questions you see there, Alaina? I know there's a lot of them.
Yeah.
Just because
Someone mentioned that they don't like joint tenants accounts for one reason or another. And why wouldn't you do a POD? So a POD stands for payable on death. And that can be used as a great tool as well for joint tenancy owners. If you are not planning on moving an account into a revocable trust and you want to make sure that account can be easily inherited, then yes, a POD or a TOD, which is transfer on death, those are great tools to use. Just again, make sure they fit into your overall plan. And then I saw one other question about where an attorney would be hired to sort out an estate. One sibling is in Georgia, one sibling is in Illinois, like me and Mike. Where would you hire an attorney? So that would be in the state where your mother passed away, where the parent passed away. All of estate planning and probate is state-based. So it's going to be where the person was domiciled at the time of their death. And that's where you would need the legal help.
Yeah, I see a question there, just a couple more on the originals. The original will is the only important original document. Courts will only accept probate courts at death, the original will. They don't want copies, because they want to be able to know that this is the actual document. It hasn't, been monkeyed with in a copy machine or what have you. The other originals don't matter that much. But again, this is important to pull those documents together, at least the original will, have them in that file record and have those notes there as well. There was a question regarding trust accounts. Remember, it's kind of like its own corporation. So it does continue and remain active, so to speak, from the point of death to the point of postmortem administration. It's just a continuing thread and no hiccups in there. So sometimes people will even resign an elderly person ahead of passing away. That can sometimes be a good idea because it triggers the authority of the successor trustee at that point in time, and there's not going to be a hiccup later on, and then you can get an EIN and start working through that process, even in the last couple of weeks or of someone's life or in advance of that. So, all right, any other question that you can see out there. There's
I think
quite a
that looks great. Yeah, we had a lot of questions.
49
Thank
of
y'all
them,
for
so it's
paying
hard to.
attention.
Yeah,
Yeah.
and many of them were answered, so that's fantastic. As I look through these, I think about 8 of the 10 we've already answered one way or another along the way, which makes me feel very good about the program today.
Yeah, so I hope y'all enjoyed everything. And again, please feel free to schedule that complimentary call if you have any additional questions. Oh, thank you.
Thanks, everybody. Have a great day.
If you enjoyed this webinar, visit savantwealth.com/guides and download our complimentary guidebooks, checklists, and other useful financial resources.